Namaskar. I am Anand Ganu, founder president Garze Marathi Global. Welcome you all for this very important event. As you all know, Garze Marathi is a joint effort. We all work together to make it success. To moderate this program and to introduce our invited guest today, I'm calling upon Mr. Abhay Potnis from Qatar. I'll talk a little bit about Abhay Potnis himself. Abhay Potnis heads Garze Marathi's Qatar chapter, and he himself is an extremely dynamic professional in IT and in developing, managing, growing and leading leading IT solutions around the world. He's an asset to Garze Marathi. Over to Abhay Potnis. Abhay, please take over.
Thank you, Anandji, and good evening, everyone, once again. Am I audible and visible?
Yeah. I'm muting everybody again. Abhay, you unmute yourself. Abhay, you unmute yourself.
Sure. Am I audible and?
Yeah, you are audible. You are audible. Please go ahead.
Thank you. Welcome again, everyone, and a warm good morning, good afternoon, good evening, and in India it is 9:30 in the night, so close to good night. Sanjay ji, welcome to Garze Marathi seminar. A quick introduction about Dr. Sanjay Bhandari. A lot of times when I've done introductions, I thought that I change the write-up given by the speaker and make it more interesting. But when I saw the write-up from Sanjay ji, I felt that I should read it as it is, and I'm doing the same thing. Thank you, Sanjay ji. It's very well written. Sanjay ji was born in Latur in Maharashtra. He's a very profound engineer. Now. He has over 27 years of semiconductor industry experience, and it's a global experience. And to tell about his career, his corporate career, he joined Philips in 1995 as design engineer, then moved as a senior director with Econos in 2000. Grew as Vice President of Engineering G-Tronics in August 2007, and then Vice President of Engineering MQ in San Francisco in February 2011. Currently, Dr. Sanjay Bhandari is based in San Francisco at MQ, and he is the CTO and Senior Vice President from August 2016. When we run these webinars as a part of Innovation Academy, I'm very happy to tell you that Dr. Sanjay Bhandari has been a very successful entrepreneur, and he has been successful into various mergers and acquisitions, where he was heading integration, startup companies, and corporate IP management. He is an innovator in the field of IoT, Internet of Things, deep learning, artificial neural networks, ANN and CNN, sensors, high-speed communication, audio, computers, and displays. Dr. Bhandari has 58 patents granted on his name. He is a guest lecturer at universities in India and USA, advisor to entrepreneurs, mentor to organizations on public speaking, and very interestingly, he is active in Indian classical music and learning classical vocal music. He has published over 20 papers in international journals and conferences, and so forth. Very interesting thing about Dr. Bhandari is he has mentioned about his bucket list that he would like to visit all the 7 continents. Out of 195 countries in the world, he has visited 26 countries, and he would like to visit all of them. And the other bucket list is he seems to be a very good hiker. His next hiking destination is Mount Kilimanjaro in Tanzania. If we get time, he may want to share more about it. Over to Dr. Sanjay Bhandari on his today's topic, innovation and intellectual property. Over to you, sir.
Thank you, Abhay, for that nice introduction. And let me start with sharing about today's slides. Can you guys see my slides?
Not yet, sir.
Not yet. Those who have questions can post them in chat. Abhay will call them at the end of the conference, towards in the Q&A session. Okay, we can see the slides now, Dr. Bhandari.
Okay, thank you. Good morning, everybody in the United States, and good evening for rest of the world. Today's topic is innovation and intellectual property. And these two words are very closely associated with each other. And yet there is a lot of gap as well, that not all innovators have been active in filing intellectual property. And this today's webinar is really intended to encourage those innovators, those entrepreneurs to take that next step. So this is all about how to take that next step and why do we need to take that next step. Abhay has already given my introduction, so I'll not go into the details of it, except I would like to mention a few facts here. One is I have had privilege to study at esteemed institutions in India, as well as here at Stanford University, and also had opportunity to work at research organizations in India as well as Europe, and number of global leaders. I have listed some of those companies over here. And then I spent a lot of my career in startup companies. And also I have affiliations with Innovation Academy of Garje Marathi and advisor to startup companies. And through this experience, I have gained a lot of deeper understanding into this innovation process and how different organizations treat this process, where are the gaps, what they could do going forward. That's what I'm going to share today. My own journey in the world of IP, as Abhay mentioned, I'm CTO of a US semiconductor company. I have 58 US and foreign patents granted or pending. 39 of these are granted. These are including 23 US patents. I have been head of corporate IP for over 13 years. And I also worked on a number of mergers and acquisitions, as both on the buyer side as well as seller side as an executive at different companies. I'm not an IP attorney, so I want to give that disclaimer up front. All the information that I'm sharing today is based on my hard learning through all these years of work at all these institutions and through all my own patents being granted into all these multiple different countries. Let's start with agenda for what we will discuss today. I'll go over the definition of what's intellectual property and what's the value of that IP. Why should you patent that? How do you create that? How do you protect that? And we'll look at a number of different types of IP, and then we'll have some time for Q&A session. So let's start with what's intellectual property. It's the creation of the mind. That includes inventions, literary, artistic works, symbols, names, images. So a lot of innovatory part that's included in intellectual property. We divide intellectual property into two broad areas, two broad categories. One is the industrial property, and that covers patents, trademarks, trade secrets, industrial designs or IDs, and geographical indications. The second part of IP is copyrights. That includes literary works, films, music, artistic work. But even, for example, this set of slides that I'm sharing with you today, those are copyrighted, so somebody else cannot just copy that and claim it to be on their own. Why promote intellectual property? Progress in any field relies on capacity to create and invent. Over thousands of years, we have seen different inventors across different countries inventing things which have lasted over years, and we associate their names to the inventions they have made, even after these hundreds or thousands of years. That's very important for this field to grow, any field to grow. Legal protection of new creation encourages further investment, and promotion of protection of IP also spurs economic growth. It creates new job industries, enhances quality of life. All the gadgets that we are using, technological gadgets that we are using, have relied or are relying on somebody's invention, somebody's IP. Now, we want to protect this IP as much as we want to promote it. Unless we protect it, it's going to be hard for inventors to get some rewards out of it. That's where World Trade Organization comes into picture, that there are member countries and there is understanding that WTO will enforce these patents into different countries. And we'll talk about those different patent treaties and how these get enforced. Let's look at what are the catalysts for IP creation and growth. The first is efficient and equitable IP system. By efficient, I mean that today it takes for any patent to be granted, it takes 2 to 5 years. Imagine if this period was longer than that, 10 years, 20 years. Would the inventor still be interested in patenting something? Probably not, because then by that time the effect of that idea is already gone. So that's what I mean by efficient. And number of different organizations play a role in that one. The patent offices in each of the countries play a huge role in that one in terms of processing that efficiently. The equitable part of that comes in terms of international patent treaties. For example, if somebody in India is filing a patent in US, he or she needs to get the same rights that a US citizen is filing in US, and that applies across the world. So that's what these patent treaties are about. The other part of this catalyst is IP law firms. These are very important. In Silicon Valley, they have played a huge role in terms of what has become today's Silicon Valley here in California. These law firms help in terms of writing patents. So innovators are typically engineers or scientists, and they're not necessarily good at the art of writing in a legal language. IP law firms take care of that portion. Academic and research institutes can inculcate this notion of creation of IP into the minds of innovators, because everybody has studied at these institutes at some point. Then there are companies, there are big organizations, and some of them have a lot of focus on innovation, and that's important. We'll talk about these organizations later on. Then there are patent brokers. If you are an individual who has filed patent and if you want to monetize that, these patent brokers are typically the ones who would look for a potential client for you, because it's very hard for you as an individual to reach out to hundreds of people to try to sell your patent. And after all, good environment where inventions can flourish and benefit all. At the end of the day, inventors need to get some kind of material benefits out of that, and companies also need to get some benefit out of that. Now let's talk about value of intellectual property. Why do we want to do this? Why do inventors want to file some patents? Or why organizations want to file patents? The first and foremost is barrier to entry for copycats. Imagine these organizations spending years of work, hard work, in terms of creating a new idea, proving that idea, materializing that idea, and somebody else just copies that idea. All the rewards would be lost. All the monetary rewards behind that innovation will be lost. So we want to put that barrier to entry for copycats. That's one of the key purposes of patents. Then using patents, you could do a number of things. You could do licensing deals with other companies and you monetize it that way. And I'll show you an example later on. Companies collect a lot of royalty based on the innovation that they have done over years. Valuation of a company depends on IP that they own. And that's where my M&A experience comes in play, that at the companies where we got acquired, the valuation of our company also was partly dependent on the IP that we owned. You can also do cross-licensing. You have seen big companies holding hundreds or thousands of patents, and they cross-license so that they are not suing each other, but they're cooperating with each other. You can also independently sell IP and you can get monetary rewards out of that one. And then corporations always have competitive edge in terms of suing or corporate war if they have a good IP portfolio. So that's very important. I'm going to share one example here for something that all of you are familiar with, compact discs or CDs. These patents were jointly owned by Philips and Sony. At the peak of sale of these CDs, there were about 2.5 billion CDs sold in one particular year. And you can see the growth and decline of these CDs. But over these years, there were hundreds of millions of dollars of just royalty earned by these companies, Philips and Sony, who owned this intellectual property. There was another third company, but then these two consortium bought out their rights at some point. So that's the value of it. You can really gain a lot of value out of your patents. And that's the reason at international level, if you look at world's top 3 economies, US, China, and Japan, these also happen to be the countries which are very active in patenting. Their patent offices have largest number of patents being filed, and I'll show that statistics later on. GDP growth is driven by innovation. As these 3 countries show, there is a direct correlation between innovation and the GDP growth that these countries had over years. Corporations are key drivers to patenting. I have listed number of corporations here from different countries. These are all very familiar names. And later on, I'll show a slide in terms of who's the top 10 corporate filers in terms of patents. Research and educational institutes can create that awareness. They need to also, they have started licensing here in US. Universities like Stanford and University of California and so are very active. I can probably list top 10 universities also that I have worked with here that are very active in licensing their own patents. Then individuals can create success stories. So they do reap rewards for their inventions. They get rewarded by their corporations for their inventions. And just as some examples, Thomas Edison, very well-known inventor, has filed or had filed more than 1,000 patents at that time. And in his autobiography or interview somewhere, he said that at the peak of his filing, he was filing a patent every 15 days when he moved to Silicon Valley. But the record in terms of number of patents belongs to a Japanese inventor. His name is Shunpei Yamazaki. He worked in flash memories. He has more than 26,000 patents filed, more than 5,600 US patents on that one. And we should also be proud that fellow Indian has filed more than 1,000 patents in this DRAM area. So that's the importance of IP. Now, if you look at the statistics of IP filing, World Intellectual Property Organization maintains a lot of these statistics. So I'm giving source, that's my source on this one. And it takes sometimes quite a bit of time for them to process these. So I'm sharing this 2018 statistics here, and I can verbally talk about 2019 statistics as well. But this is indicative of the trend that you see globally now. China Patent Office happens to be the one which is receiving largest number of patents in the last 2 to 3 years. In the year 2018, 1.5 million patents were filed in China Patent Office. US Patent Office received about 600,000 patents. And that growth in US has been fairly steady, slightly increasing, but you can see that China is trying to increase their rate. And Japan also has about 500,000 patents being filed. Now, in this same chart, you do see India over there. India has about 50,000 patents filed in that year, 2018. And these are the patents filed in Indian Patent Office. So only 1/3 of these patents are filed by Indian residents. About 2/3 are filed by foreigners or foreign corporations on Indian Patent Office. These are top corporate filings. Again, this is statistics from last year. You can see IBM is at the top, filing almost 10,000 patents. And then down, you can see all the lists. And these are the companies which have been very active, not just in inventing, but also reaping rewards. I mean, you can see that these are top earners in their own categories. Now, the question comes up is, how does India stack up in this? So I'm going to quote this article from Times of India. This is again from 2018. I have compared the last year's statistics to this one, and for India, they have been pretty flat in terms of the number of patents that are filed by these same institutes. So these statistics numbers still hold. And one of the conclusions that this article was trying to drive is all the Indian academic and research institutes combined together filed 781 patents in that year, 2018. One single corporation in US files a lot more patents compared to that one. And you might say, okay, that's an unfair comparison because there are a lot more resources for corporations compared to academic institutes. So I put together a comparison of US universities, and you see California, just the Californian universities file almost equivalent number of patents that all the academic and research institutes file throughout that year. And these, by the way, are also the top universities which are not just filing patents, but they also license it, and that's a significant amount of revenue for these universities. Let's talk about what prevents people from patent filing. The first is lack of awareness, and that's where webinars like this one are intended to create that awareness. And we are trying to reach out to people, encouraging them. And there are a number of governments as well as non-government organizations now in India as well, which are dedicating efforts to creating that awareness. Then it's not a priority for some, especially for research institutes. Sometimes they weigh in publications versus patenting. And in my experience working with the academic and research institutes, publications are valued highly just because they get granted within a certain period of time, 6 months, a year, and that's important for research institutes. Cost is a big deterrent. I'll talk about cost later on. It does cost 10 to 20,000 US dollars if you are filing a patent here in US throughout the duration of that patent. Don't know how to patent. That's the catalyst that I previously spoke about. Those are very important. So IP law firms and others can play a big role into that process. Resources, again, number of resources are required in terms of IP filing. So that also is a preventive thing. Local ecosystem that values patents. That has to be at company level, at national level, at funding level. So that's the important part. Let's look at what can be patented. The patentable subject matter is a process or method, a machine or circuit, a manufactured article, or a new composition, such as pharmaceuticals, for example. Novelty is a key aspect. That's the determining factor in terms of whether a patent gets granted or not. In the legal language, we call it prior art. So if somebody has invented this same thing or something similar from in the past before you, then that's called prior art. And a patent office, when they examine that patent, your patent, they will look at prior art to see whether there is something that's obvious from the prior patents that either lets you grant your patent or does not allow you to that patent to be granted. There are also some restrictions in terms of your publication or public disclosure of this idea that you are trying to patent. So you cannot be disclosing that idea more than a year before, otherwise you lose your rights to the patent. For utility patents, there is also requirement in terms of that being a useful invention. Otherwise, that's not a utility patent. The exceptions are design patents. So if you come up with some gadget with certain shape and you just say, I want to patent this shape, that's possible. Non-obviousness from prior art, this is the most important criteria. And many times when you file patent, the patent examiners are going to come back with what's called as office action. Talking mostly about non-obviousness, because in their examination, they're going to look for if this is something that can be derived based on the prior work. Let's also look at what cannot be patented. Just idea cannot be patented. You cannot say that I want to design there has to be a rocket that goes to moon 3 times in a day. That idea cannot be patented. If you say, okay, this is how you can do this, implement this, and you write it down in terms of what makes it possible, then that can be patented. Mathematical formulae, naturally occurring substances, laws of nature, or processes done with human body cannot be patented. Now, the next question is, okay, you came up with a good idea. Where should you file your patent? Every inventor thinks that his idea or her idea is so great that we should protect it all over the world. Now, unfortunately, that's not as easy as we say it, although on some patents we try to do that. The reason is it costs a lot. If you have to patent it all over the world, it will cost you more than 100,000 US dollars, just in rough numbers. So you have to make hard decisions in terms of where to patent it. And the criteria that we use for deciding that is, where is your competition? Because you are protecting your idea with respect to your competition so that your competitor doesn't come back and patent the same idea. Cost of patenting in those territories is important. For example, US, it would cost you 10 to 20,000 US dollars to patent and maintain that idea over years. Ability to protect in those territories, because after all, in these patents, you are pretty much giving away a recipe of how your idea is going to work. If you don't have ability to protect in certain territories, then you are pretty much given away this recipe for free. And that's where these IP treaties come in play, that they help you in enforcing these patent rights. So let's talk about some of the key patent treaties. First of all, the patent laws and processes do differ from country to country. So if you are filing in another country, it's best to hire experts from that country so that they can word it in a language that that country will help in reinforcing. But then some of the patent treaties also come into play in terms of helping on reinforcing. Paris Convention Treaty is one of those. There are 176 member countries as of now. And some of the key highlights of this one that each member country guarantees the same rights to foreign inventors as their own citizens. That's important. There has to be fairness in that one. And it preserves the original filing date as long as the patent is filed in other country within certain duration. For example, if you filed a patent in India, you can file within certain duration a patent in US, for example, within 12 months. And for trademarks, it will within 6 months, so that you can still retain the original rights or original date of your original filing. Then the other most important treaty is Patent Corporation Treaty, or PCT. There are 148 member countries, including US, India, and so on. And the way PCT is important is it provides a standardized application format and centralized filing. For example, if I'm filing my patent, I would first file it at US Patent Office. But the second patent or the extension of that patent, I would file it as a PCT patent. And then I would go into the member countries. If you want to protect it in a geography, like for example, Germany or France, then I would make use of the PCT application as a reference for that, so that that application uses that as a standard. When talking about patent process, I want to share this quote from Thomas Edison, where Edison said, "Genius is 1% inspiration and 99% perspiration," which is very true. But I want to change it. I want to change it to this one. Patent is 1% inspiration and 99% perspiration, which is literally true based on my number of patents that I have filed. There is a spark of an idea. If you're working on some idea, if you're trying to solve a problem, then suddenly some bright day, a bright idea comes in your mind, and you know at that moment that I think this is it. This is the idea that's going to solve it. So that's the spark of idea. It takes a few moments to come with that. But then the rest of the process is very tedious. If you are filing a patent, you need to document it in a hardbound notebook with witness signatures. This has been, by the way, a very traditional procedure. These days, you don't need to necessarily follow that. We use electronic medium these days to document that idea has been there. And companies, every corporation has certain format in terms of documenting that idea. and then you send out that idea, share it out. So you're these days not bound to be hard bound really in a notebook. But the next part is the most critical part and most time cumbersome part, which is that you have to prove that the idea works, it's practical and has significant benefits. And in my experience, this has been the hardest, at least in my early days when I started filing patents, that there is a lot of skepticism around all of us. Anytime there is a new idea, people would come and say, okay, first of all, if this is such a big idea, why didn't somebody patent it before you? So that becomes a deterrent in that one. And I remember on very first time that question was asked to me, my answer to the professor, this was a professor from IIT, was that if everybody thinks that way, then nobody would file any patent. You have to always have faith in yourself that you are capable of coming with new ideas. And it's very likely that that idea has not been thought before. So you have to give it a fair shot in terms of going through prior art and then proving yourself that there is indeed a new idea. At many of these organizations, big companies, there are patent committees, and they go through the process of scrutiny of that patent as well. So there is this help from patent committee in terms of filing that, but there is also scrutiny. We come across probably 10, 15 patents every quarter, and then we have to make sure that what's worthy of patenting. Prior art search, because we have to make sure that this is non-obvious from prior work. And I showed you in the previous slide, there are millions of patents out there. So even in your own area, even though you think that this is a new idea, there could be thousands of other ideas, very similar ideas. So you have to go through this prior art search. This is a very tedious procedure. Most of the time, patent lawyers will help you in doing this search. Then you have to put together patent application and claims. Again, patent lawyers help in that one in terms of putting that into appropriate legal language. And this process by itself takes quite a bit of time because it goes through iterations. You as an inventor read through that, your IP lawyer reads through that, and after several iterations, when you are happy, then you can file that. And once you file that, patent office will assign certain milestones to that process. So I'm going to break down those milestones that are used by patent process. First one is called provisional patent. What it means is if you have a date of invention and you are in a rush to file that right away, and you hadn't had chance to really go through the whole details of proving it and so on, the patent office makes it simpler for you. Some of the patent offices, they allow you to do a provisional patent filing. That preserves your date of invention, and you don't have to include all your final claims into that. It preserves your date, and then it files something saying this is the subject matter. And then within 12 months, you have to file non-provisional or final patent after that. So if you don't file that, then your patent is invalid. Then essentially it doesn't go anywhere. After you file your non-provisional patent, then patent office is going to assign examiners to that patent, and he or she is going to do office action. So this patent examiner is going to go back, look into patents in similar field, and come back with a response, which is called office action in the legal language, which will say, if you are lucky, it will say, okay, your patent is granted, but there is less than 1% chance that will happen that way. Most of the time, the patent examiners will come back saying your patent is declined because X, Y, Z, all these reasons. And because of this, look at these 10 other patents which are in the similar field. And X, Y, Z, patent A said this thing, patent B said this, you add A plus B, then that's why your patent becomes obvious or your idea becomes obvious. And there are so many pages and pages of these office actions in terms of why examiner thinks that certain patent should be granted or not granted. You go through that again with the help of your patent attorney. And if you're successful in going through that, and this could take several iterations, that's why it takes 2 to 5 years to get a patent granted. But if you go through that process, have perseverance to do that, then eventually you could succeed in getting that patent as long as you are able to establish that your claims are have a novelty and that it has not been a prior art. Once the patent is granted, uh, throughout that process, after non-provisional filing, you also have certain duration to do foreign filings. For example, if I filed my patent in US, if I have to file patents into Europe and Japan and India and so on, there is certain duration, as we discussed earlier. In that duration, I have to file those. Once a patent is granted, though, you are not done. Patent office, in order to maintain your patent, is going to ask you to pay annuities for those patents, and those also are very expensive. US patents are valid for 20 years, and there are then 3 milestones in which you have to pay these annuities as an inventor. Your corporations will do that. You are filing that through your corporation. After the patent has expired, anybody can make use patent without permission of the patentee, provided the matter is not covered by other patents. So what we do at corporations is, I know the validity of one patent is going to be 20 years. If I want that to be extended beyond that, 25 years, 30 years, then after a certain duration, 2 years, 3 years, we would file something what is called as a continuation in part patent. So that claims priority to the previous patent. And then it has some additional new matter, otherwise it just cannot be a copy of the old patent. So if there is a continuation work there and additional inventions there, then you can get continuation in part other patent granted. And that CIP patent will have another 20 years. So that way you can extend the validity of your original idea. Let's think about innovation, because all this patenting process relies on you coming up with innovation first. And let's take a moment to see where do ideas come from. I'm going to again quote Thomas Edison on that one for this very famous quote, which is, "Opportunity is missed by most people because it is dressed in overalls and looks like work." And my own experience in this area is that most of my ideas came from the problems or challenges that I was trying to solve. So if you solve a difficult problem, then you can patent that problem. I still remember the history behind my own first patent, which was invented here when I moved here to US 24 years ago. That I was working with a client company, which was using our chips into storage technologies used for personal computers. And I happened to have visited there and I gave them a presentation and I said, okay, these are the specs that we can meet for this particular chip. And then I came back, I had to eventually deliver this. And then through that process somewhere, just a few weeks after, I realized that there was a mistake in the way that we had previously modeled this whole system and that I couldn't meet that spec anymore. So I had two options. I had one option was to just go back to this customer and say, sorry, we couldn't do that. We thought we could do that. The second option was to come up with something new that could make that possible. And I remember this was 8 o'clock at night when I realized that this was not working. And I stayed until midnight that night at my office, just looking at other ways to somehow overcome this limitation that was coming there. And somewhere around midnight that night, a flash came, finally idea came that I thought could work. And I couldn't resist, but I had to just share that with somebody. So I called my other co-worker from France. It was morning over there, and I shared that idea. And then he also thought that this should work. We then eventually did more work on that, and I filed my first patent based on that. So it's very rewarding history to me. It's a good memory. But I wanted to share that today with you because in your areas of work, you will come across a lot of such occasions where you might curse your manager or your employer and say, okay, come on, this is impossible that he's asking me to do. Why should I do that? And if you think the other way around, saying this is opportunity, this is a challenge, and if you solve this difficult problem, it's going to create a new invention potentially for yourself, for your organization, and that would be a key barrier to entry for your competitors going forward. So look for problem solving in your own areas of work. The second thing comes from analogies. There are famous examples on that. I'll not go into the details of that. I'm sure all of you have heard these stories in terms of these inventions. Then ideas could also come from intuition. Experimentation also gives a lot of ideas, especially in the pharmaceutical world. You see all these, for example, now we are talking about COVID vaccines that all these corporations are developing. This comes through a lot of experimentation. There are all these permutation combinations, and some of that is going to succeed. And you don't file everything that has failed, but the ones that are top candidates of success, then you do file those, and that becomes patents of those companies. And of course, experience plays a big role in that, because just talking about this COVID formula or vaccine formula, there could be hundreds or thousands of permutation combinations of making it happen. So your experience does count in terms of that particular field to say that, okay, let's focus on these top candidates. That's most likely going to work. When do you know it's worthwhile to patent? For every inventor, it's a great idea, best idea since sliced bread, and you think that this needs to be patented right away. So, but then you know how much expense that is to file that patent. So you have to calculate that return on investment. Here are some criteria that I would suggest to inventors. One is, if your idea is likely to be a foundation of a startup company, if you're starting a new company and that idea is a foundation of that, then you must file that idea, because that's going to be a key IP for your company. And that's how your company is going to be valued. And you have to have barrier to entry for other companies. Otherwise, a startup company, there are thousands of these coming every day. Somebody else could easily do that, or might have already done that across some part of the continent. The second time you want to file is you are solving a difficult problem, and that you think you can get a competitive edge. And I just gave some examples, some personal examples on that one. Corporations have patent committees. I have been heading these committees over years, and we have some set criteria in order to decide which patent should be filed and which should not be. If you are an individual and trying to think about patent, then you have to think about cost versus benefits calculation to see whether there is going to be really monetary rewards behind that patent. Otherwise, you'll spend tens of thousands of dollars just for the sake of, okay, you can be proud that you have got one patent, but then there has to be some return on that one. We talked a lot about patents, so let me speak about other parts of intellectual property forms, and these are trademarks, copyrights, and trade secrets. Trademarks are any word, slogan, symbol, design, or a combination of these, which is used for identification of goods and services. And some examples are, for example, the way these words Coca-Cola or Nike are written, and the colors, everything that's used around that. That can be trademarks, and these corporations have done that. But if you are in a world of service and you are not selling a particular good, then the same applies to a service mark. For example, FedEx is a service mark, as it's shown over here. Copyrights, as we discussed earlier, is the original work of authorship, but it has to be fixed in tangible medium of expression. If there is a verbal description of something, it cannot be copyrighted. It has to be on tangible medium, like it has to be written up somewhere or recorded on something, either as audio medium or video medium now. So all of these can be copyrighted. What is not protected is again same, ideas, procedures, concept, principles. So those cannot be protected. Term of copyright is life of author plus 70 years. Trade secrets differ from the other forms of IP in that they are also very critical for business, but they are not typically written down somewhere. They are something that is held as secrets by those organizations. And they have to show that there is a reasonable effort to maintain its secrecy. For example, the formula that Starbucks uses, for example, for making coffee or tea, a particular blend, that would be their trade secret, and they would try to preserve that. Manufacturing processes, technologies, recipe also fall under that criteria. And again, WTO will help you in terms of patenting your or preserving your trade secrets. If you decide to sue somebody or somebody else copies that, it's not going to be easy process, but there have been instances in the past. How do we incentivize creation of IP? We talked about innovators need to be incentivized. So first of all, you have to create awareness, provide information, and then government bodies come into play where they can also have policies to encourage. In the next slide, I'll show you about the Indian government and non-government organizations encouraging and providing rewards nowadays. Corporations do provide monetary incentives to employees, but at some of the companies we had Hall of Fame, where if you had certain number of patents, you would be in this Hall of Fame, and we would be treated very royally just because we had so many patents behind us. So that was really a good feeling for inventors at that time. Many companies display patent plaques in their lobby as well, which is again a great encouragement for inventors. Research institutes can also do a similar part. They have to weigh in publications versus patents, and individuals should leverage the employer support because the cost of filing should be borne by these companies, and sometimes you have to convince your employers to do that. There are a number of patent filing incentive schemes in the recent years in India because I think there is a bigger realization now that patenting is very important. In the Indian context, last week, for example, Dr. Mashelkar spoke on this Garje Marathi forum, and he gave examples of the famous cases like turmeric, medicinal properties of turmeric, and basmati rice was another case. And through these cases, India won in those cases. There was a lot of awareness in India for why patents are important. And given that we are members of PCT and WOT and so on, WTOs and so on. So we need to make sure that we have equal ammunition in terms of our own IPR. So there are central government schemes and state government schemes. I have to give a disclaimer, I haven't used any of those, but I really would like the inventors from Indian side to investigate these and make use of these because these schemes are there to help you in terms of either reimbursing your patent costs or subsidizing that or helping you in terms of filing these patents. Final thoughts, we need to grow awareness at all levels regarding importance of IP. Corporations, businesses, research and academic institutes need to foster this innovation and create this ecosystem which is IP friendly. Innovators need to be recognized and rewarded for their ideas. So think about how do you create that ecosystem everywhere. And countries need to have long-term strategy to grow IP to spur economic growth. With that, I'm going to end my speech, but I'll now open up to Q&As if there are any questions now.
There are questions. I think Abhay will call out them.
Sure.
Thanks a lot,
Dr. Bhandari. Thank you, Dr. Bhandari. Thank you so much.
It's my pleasure.
Am I audible?
Yeah, you are audible. Please carry on.
Perfect. Thank you. Dr. Bhandari, there are a few questions, but before that, a quick question from me. You spoke about innovation and IP. Right. If there is an invention, how would IP play a role instead of innovation?
So there are two types of it. If you are intending towards something which is a derivative form of something which was previously there and you are carrying on to that, that's how we are probably differentiating between the two, and something which is a fundamentally different core research. Is that what you are hinting at, Abhay?
Not really. My definition of innovation is something which is already present and on top of it we do the innovation. Like telephone was an invention, but wireless and other things are the innovations on top of it. Now today we spoke about innovations and IP. So the idea was already present somewhere, the basic idea which was the invention. So what I wanted to say is invention is an IP or there is an IP when there is an invention?
Yeah, so as far as IP is concerned, inventions and innovations are treated the same way because these are original ideas. Although for example, in your example, telephone versus wireless, you think are derivatives of one another, but wireless requires invention of its own. So there is a lot of fundamental invention in that area as well. So IP treats both of them equally.
Okay. But at the end, well, I have a question. At the end, I have also a question.
Sure. There are a couple of questions from Abhijit Nakate, but I will take one question from him, and then as the time comes, we will have, everybody's questions we will have. Abhijit's first question is, how effective or easy is to file a patent in different territories? For example, Britisher filing patent in USA.
These days, it's very accepted procedure that in the territories where your customers are and where your competitors are, you have to have filing there, because eventually when there are lawsuits, those will be played out in those respective territories. So for example, there would be corporations who would say that we would follow California law or whatever. And if you have patent in that jurisdiction, that helps, as opposed to saying, okay, I'm now fighting with a British patent versus US patent. So it's important that you protect yourself into those territories.
Okay, I believe it has answered for Abhijit.
Abhishek.
There is a question from Devdatta Norte. How patents compare to trade secrets?
So trade secrets are not written down. They are not filed to a patent office. As opposed to patents are written down very specifically in terms of your novelty, and they are filed. Trade secrets are something that's a secret that you keep to yourself, and the corporation tries to hold that secret. Now, most corporations, or in these days all corporations, would have their employees sign in a non-disclosure form where it says you cannot disclose the company's ideas. So both of the ideas are prevented from being disclosed outside, but trade secrets are not filed as a recipe sharing with the patent office.
Okay.
Thank you, Doctor. Very specific answer to a very specific question. Tushar Deshpande. His question is, advantage of filing patent in India for an Indian who is working in the US. So I believe Tushar is working in the US. He is asking what is the advantage of filing patent in India.
So it goes back to the same. You would only file in India if you believe that your customers are India. Let's say you are working on a particular device, and if that device has a market in India, and that's why you want to protect it over there, or your competitors are there in India, so that you want to protect in that territory. So for those two reasons, you would file it in India. And I'm saying India, but that's applicable to any territory.
Okay. There is a statement from Dr. Pushkar Cheswal. I believe he can write directly to you, Doctor, on that. Instead of publicly asking this question.
Sure, yeah.
Anandji, you had some questions.
Yeah, I have a question. See, this patent filing is an expensive procedure, no doubt about it. Are there any companies or any organizations who will take care of initial expenditure at the cost, and take a share of, it is like they spend on my patent filing and then they join me in the income after that, take a share in my income after filing the patent?
That's an excellent question, Anand. I see, living here in Silicon Valley, I see all kind of examples of how people work out different things. And in my own experience, yes, somebody has done that, that you provide a share. For example, you are starting a company. If your patent attorney is trusting your ideas, you might give him certain number of stocks in lieu of his writing patents. So at least that portion, at least you can take care of, which is patent cost is patent attorney cost is a big part of that patent cost. Now in India, these organizations, both government organizations and non-government organizations, help you in filing, so they are bearing the cost of filing, or sometimes reimbursement. So both types of mechanisms these days are available. And I have again personally not used it, but just reading through these organizations, it seems this is possible there.
So there are companies who are doing exclusively this job, like they underwrite your patent expenditure and then they take a share of your profit afterwards.
That's right. That's
They
right.
advertise that, which
You have,
we
you
can.
have to look for those. They don't necessarily advertise that, but through your network, you can come across some patent attorneys, and if you convince them that that's a good idea, then they would do it.
Okay. And second, my second question is, Abhay, do I have time? Anybody else waiting in the line for the question?
Yeah, there are a couple of them, but you can go
Okay,
ahead.
I'll just ask. If filing patent in India is fairly less expensive as compared to US, so why not file? Because we are part of that 124 nations. So why not file in India only? Why file here?
Okay, that's a good question too, but it goes back to my previous description. You want to file and protect your patent where eventually your goods are going to be sold. So, for example, many of my patents got used into, for example, PC, personal computers related things, or into the DSL modems, or into headphones, or all those kind of devices, smartphones nowadays. And the larger markets were here, or the manufacturers were based in either here or, for example, in Asian countries. And then we filed in those countries particularly. So that if we file it in India, yes, it has a value, but that's not your market. So tomorrow, for example, yeah.
Does it have the same protection? Means I'm still protected in US also, isn't it? Even if I file in India.
You can make use of that patent as a basis to say, because I had that patent in India, that I would come after you, and because of these treaties, that would be again treated.
Valid.
Yeah, it's a fair claim, but having it in the same jurisdiction will help in terms of that litigation when it comes to that point, because
Okay.
then at that point it will be US patent versus US patent. Just to give you an example, if you had a US patent and your competitor was selling in US, the immediate relief that you could get as an inventor is that you could stop your competitor from selling any goods in US, and the US judge can give that very quickly. That and you have seen these kind of claims that have come up in the past. So
Okay.
that's the beauty of it. Indian judge cannot ask um, goods should not be sold in US territory, right? That's very hard. That's not their jurisdiction.
Okay. Okay. Understood. Thank you. Thank you, doctor.
Yeah.
Abhay, please.
Sure. Sunilji, there are three questions. Can I finish that and then come to you?
Yeah. Yeah. Okay.
There is a statement from Dr. Rohini Kulkarni, good information in very simple way, avoiding unwanted technicalities. Her question is there any support system where individual files patent, bag it, but unable to explore it commercially for betterment of the mankind?
So, Rohini, that's a great question. Actually, vast number of patents fall into that category, that sometimes individual entrepreneurs, innovators try to file a patent because they believe in their idea. They go through the effort of filing that, but it's very hard to follow up in terms of who's copying your patent and how do you go after that entity. And going after large entities, large corporations is extremely difficult. So you need to have some help from some organizations who would back you up on that subject.
Okay.
Okay. There's a question from Prasad Pimplaskar. I'm sorry if I pronounce your surname wrongly, Prasad. We do see a lot of idea licensing in academics, but why is it not prevalent in industry? Is the question. I don't know if it is true, Dr. Bhandari, but this is the question.
So these days, from research institutes, or the research institutes are licensing ideas to industries. Again, last week, Dr. Mashelkar spoke about that. Ideas patented at NCL. He said he has licensed it to a number of US corporations. And here in US, that has happened all the time. In my personal experience, I have licensed patents from research institutes here in US.
Okay.
Perfect. Thank you, Doctor. We started at 8:02, and Anandji, if you allow me, there are two questions.
Yes, please.
I think this question already, Dr. Bhandari, you answered when Anandji asked, but let me read it for you. This is from Convenant, somebody. what mechanism ensures that the patent conflicts are not observed when filed in different geographies? I think you answered it already, but anything more you would like to add?
So every patent office is going to have an examiner of their own. For example, if I filed a patent in US, and if I file that similar patent or extension of that into, let's say, France Patent Office is going to examine that on their own criteria, looking at another set of database. So each of these patent office is going to look at their own database before granting that patent. And they may have independent views, but by that time, if US patent is granted, you could make use of that to say, I have gone through these claims. And then, of course, you have to fight out these other claims from this other territory as well. So it's not necessarily conflicting because everybody tries to look at as many prior art cases as possible. But the respective patent offices do rely on their own databases a lot more.
Okay.
Thank you, Doctor. I think there was a question from Sunil. Sunil, please go ahead.
Sunil, yeah. Unmute yourself. Sunil, unmute yourself. Sunil, unmute yourself.
Yes. Thank you, Abhay. Thank you, Anand. And thank you, Sanjay ji, for that wonderful talk. You will be delighted to learn that I also come from ancestral villages from around Latur. So I'm really glad to see somebody from Latur. Anyway, my question is actually the World Intellectual, you mentioned World Intellectual Property Organization and WTO. The general complaint, I mean, I don't know too much about them, but I know just a little bit. And the general complaint there is that in India, there is a lot of flaunting of international patents in several areas, particularly in entertainment and so on, music and so on, those industries. So how is India addressing that so that we have a better image outside in terms of not just filing? Of course, one of the things you mentioned that we should be filing more patents. But on the other hand, we should also, if you're doing that, we should also be respecting other people's patents more. So what is your view on that? Thank you.
Okay, so there are two parts of it. The first one is when you refer to copying of movies and so on, that's the copyright related part. And it all depends on whether the original author or original somebody who has copyrighted that will go after these other ones who are copying that. In the original case, if there are not, in all these mechanisms, there is also onus on the inventors to make sure that they have taken the right steps to protect their IP, whether it's a copyright or whether it's a patent. If that's not there, then of course they have nothing to go after because they can verbally say that this my idea got copied, but they don't have means of following up on that one. So that's why awareness is important both on the side of the inventors as well as on the side of somebody who's copying that. Once that awareness goes, then at that point people would be very conscious of not copying somebody else's idea that lightly. It will happen over time, and some of these cases that we have seen, the most famous cases that came up in the last 1 or 2 decades, that have created that awareness, that has helped in creating that awareness in India.